President Cyril Ramaphosa has signed 3 new pieces of legislation into law aimed at strengthening efforts to tackle gender-based violence. These are part of Ramaphosa's National Strategic Plan on Gender-Based Violence and Femicide. It follows the 2018 summit on this issue. Well, to discuss how these laws aim to change the landscape, we're joined by MOSAIC Training, Service and Healing Center's Kerryn Rehse. Kerryn, good evening to you. Thanks for your time. Firstly, of course, each of these pieces of legislation seeks to do different things, but all of it are contributing overall to the fight against gender-based violence. In what ways do you believe that this will tighten from a legislative perspective then the regulations around gender-based violence?
Good evening, Kathy, and thank you for having me on your show. So these bills, it's a very exciting time for gender-based violence work in South Africa, seeing these bills now being signed into amendment acts. And like you rightfully said, these acts are being amended in order to strengthen the protection and access to services for victims of gender-based violence. So there are 3 pieces of legislation. The first is the Domestic Violence Amendment Act, and that seeks to strengthen the protection mechanisms for victims of domestic violence. And then there's the Sexual Offences and Related Matters Act that seeks to strengthen the regulations around sexual offences in the country. And finally, the Criminal and Related Matters Amendment Act. And that deals with issues such as tightening bail conditions, increasing minimum sentence for certain offences. So you can really see that there is a legislative commitment to the protection and increase in access to justice for women and children in the country.
Let's look at the Sexual Offences and Related Matters Amendment Bill, particularly what it does for the National Register of those who've committed sexual offences and how it expands the scope of this database.
So before, this database was really limited to those people that were convicted of a sexual offense. Now, we know that convictions for sexual offenses in the country are very low. We're looking at 5 to 7% conviction of those reported cases. So we know that not all cases go to prosecution, but of those reported, we have a very limited number of cases that are convicted, which means that those persons who are alleged to have committed offense or have committed an offense and not gone to trial, they did not appear on this register. So the Amendment Act will now seek to broaden that scope, as you said, to include persons that are not necessarily sentenced, but they might have suspended sentences, but anyone who has been convicted of a sexual offense or has received a suspended sentence will now be included on that register.
One of the new offences that we're looking at, particularly under this amendment, is that of sexual intimidation. Let's talk a little bit about what sexual intimidation is.
So sexual intimidation would be any coercion, it would be anything around being threatened for exposing somebody's sexuality or exposing somebody's sexual act. So anything where sex is used as an intimidation tool. So we know that when people are intimate, they might share certain images or certain things of their relationship with each other, and that can then be used to intimidate the other person. So those are some of the forms of sexual intimidation.
Kerryn, let's look at the Criminal and Related Matters Amendment Bill. And part of that is really in responding to what we've seen take place in our courts, where many times survivors of gender-based violence talk about the re-victimization that they put through when their matters are going through the court process and are being basically processed by the criminal justice system.
So this Amendment Act really seeks to address that. So it's looking at more victim-centered ways to provide evidence within court. Before, you would have in-camera interviews reserved solely for minor victims of sexual offenses or crimes of gender-based violence. This is now being extended to all victims of crime. It also looks to reduce secondary victimization through a number of mechanisms that are proposed by the bill. But in addition to that, it also seeks to strengthen and regulate the bail conditions. So making sure that this is consistent, but also that bail conditions are more stringent for perpetrators of or alleged perpetrators of gender-based violence, and then also increasing the minimum sentence for certain offenses, which include instances of rape, murder, and compelled rape.
All right. I think what we'll do is that we'll wrap it up with the Domestic Violence Amendment Act. And there we really see something that has long been spoken about, which is transitioning and integrating the provision of justice through the various means that are available. And it's really going to be interesting to see how the protection orders that one can now be able to apply for on a 24-hour basis, how that is going to be processed by the courts.
So for MOSAIC, this has been our focus since it came into play in 2020 when we started looking at the amendment of this bill. The Domestic Violence Amendment Act now has some of the most significant changes out of the 3 amendment acts. One of them, as you mentioned, was the ability to apply for a protection order 24 hours of the day electronically, which means you don't need to take off a day's work or find transport money or actually go and wait at a court and place yourself in danger by being at the court. So this is revolutionary. It's something we haven't seen before in our justice system. We wait to see how this will be implemented, but what it does mean for the victim of domestic violence is that this process is now fully decentralized. It means that somebody can apply for the protection order from their home, from their place of employment, from an organization like MOSAIC. We're able to assist in applying for that protection order. And if a magistrate sees cause to issue an interim order, they can do that without the applicant ever going to the court. So this is a major advancement in terms of the Domestic Violence Amendment Act.
Kerryn, it's not unheard of, particularly in matters of domestic abuse, where the one party applies for a protection order, and very soon you then see the other party applying for a protection order as well. How do you see then this move to the digital space playing a role in terms of mediating is not the right word, but in organizing those orders?
So that's exactly what we're seeing. We're seeing currently the system is very paper-based. So all records are kept and filed on paper, and there's very little that is stored at a central electronic repository, as the Act now puts it. So this move to a centralized database will mean that it can very easily be found if there is an opposing protection order, and that will allow the court to deal with these matters simultaneously. And what that does is it lessens the risk of one protection order cancelling out another one, or where the police arrive and there's 2 conflicting protection orders and they don't know which one to then actually apply in the situation. So that deals with that matter, but the central repository also allows for the very easy access to these documents. So currently, if an applicant loses or their protection order is damaged, they need to go to the court where they applied. The copy then needs to be located, a copy made and provided to the applicant, where now they would be able to approach any court to have that matter printed out and provided to them. It also allows for the electronic service of these documents. So we hopefully will see a reduction in cases that are withdrawn from court because the respondent is not able to be located, because there will be the opportunity to serve these documents electronically.
Kerryn, let's talk about whether or not you believe we have the appropriate infrastructure to be able to administer this legislation.
So it's one of the challenges we have seen in implementing legislation in South Africa. We have incredibly progressive laws, especially when it comes to gender-based violence, and these amendment acts are no different. But we do struggle with the implementation of these laws. What is positive and what we see a movement to now is a strong focus on the monitoring of legislation. And the National Strategic Plan on Gender-Based Violence and Femicide, it is made up of 6 pillars, and each of these pillars is responsible for oversight over what is happening around the state's response to gender-based violence. So Pillar 3 of the National Strategic Plan is tasked with firstly making sure that departments are ready to implement this legislation, and secondly, to provide oversight over the implementation. So that's something we haven't seen before in terms of gender-based violence legislation. So it's definitely a move in the right direction for the country to ensuring that legislation is implemented in the way that it should be. And as MOSAIC and other civil society organizations, this is one of the key roles that we see ourselves playing in legislation going forward, to making sure that the regulations speak to what victims require, but also that it's being implemented correctly at all levels, especially at a local community-based level.
Kerryn Rehse is the Advocacy, Policy and Research Officer at MOSAIC.